Welcome back, and I'm your host, Patrick Bailey, and this is the Love 'em or Lose 'em YouTube channel.
Hi, I'm Mark Bailey. I'm an attorney. I've been practicing in the state of Michigan. Primarily, we call it matrimonial matters or family law matters involving children, custody, you name it, and divorce, sometimes not divorce, but that's primarily what we do.
And Mark, today the question for our viewers is, what happens if our significant other or our spouse decides to withhold the child from us?
Well, if you were here last or watched this for last week's segment, you'd understand some of the consequences of moving out of the home. And that's really where you run into this problem where somebody has moved from the home for one reason or another. The spouse has said, look, you need to leave. Or alternatively, you have left saying, look, I need some space. We need to work something out. And generally speaking, once you move out of the home and the spouse does not allow you to see the children, there's really not a lot you can do until you have a court order that allows you to see the children and to provide a specific parenting time schedule. Why is that? Well, if you move out of the home, or let's say a spouse moves out of the home, moves in with parents, and you want to see your child or children, and that spouse says, no, you're not going to see them, which unfortunately happens way too often, and unfortunately is some of the advice that I hear coming from other lawyers. What are you going to do? Are you going to go over to the home of her or his parents and demand to see the children? Or are you going to show up to the school and take the children or take the child after school? No, you're not going to do those things. Somebody may tell you that that's okay, and it's not parental kidnapping. I don't want to be too dramatic about this. However, that's not a good thing for your child to see that kind of conflict. Or if you go over to somebody else's home to try to take the child, guess what? Police are going to get called and you're going to end up getting carted off to jail. So what do? You have to, generally speaking, file a court action, which gets the court's jurisdiction to be able to award custody and parenting time orders that allows you to see the children or have custody of the children in their best interest. Now that process, although it's streamlined in many counties, can take 3, 4, 5 weeks. And so, again, if you were listening last week, I said one of the reasons that you don't want to move out of the home is because it can have some very, very significant financial consequences, but it can also have, more importantly, serious consequences on your ability to see your children.
Now, Mark, does it matter if we're married? I was there at the hospital for the birth. So does it matter if we're married or whether we were just dating?
Yeah, it matters a lot, really. In the state of Michigan, if you're married and you have a child, that child is presumed to be a child of the marriage. If you are the biological father, but or biological parent, primarily the father, the mother has all the rights when the child is born, and there's no they're not married. You have to establish your paternity through either an affidavit of parentage, which is oftentimes signed at the hospital, or you have to have paternity established through a court order. But in either of those cases, whether you're married or whether you're not married, if a parent withholds the children, you need to get ready to be active, not just sit back and hope that it changes. Maybe it will, probably it won't, but you need to probably get with your lawyer, be prepared to get an action started so that you can get the court involved in you being able to see your children. The longer you go with not seeing your children, the harder it is to see your children, the longer it takes, and the bigger negative impact it has on the child or children. Now, why would a parent do that, you might say? I don't know the answer to that. I wish I did, and I wish it happened a whole lot less than what I see it happen. But unfortunately, I see it all the time. Why? There's a whole bunch of reasons for it. Primarily, anger. One parent, one spouse being angry at the other spouse and keeps the children away from that spouse. Now, they may not say it. They may not say it that I'm angry, that's why I'm doing it. But in reality, that's why it's being done. Because it's very harmful to keep a parent from their children. unless of course the parent causes or potentially causes danger. We can get into those kind of things, but I'm not talking about that. I'm not talking where a particular parent represents a danger because they're an alcoholic or a drug addict or a felon or abuse. I'm not talking about that scenario. I'm just talking about the scenario where one parent has decided that they're not going to allow to keep the other parent who was involved in the child or children's life from seeing that child.
And lastly, Mark, you said it could take 3, 4, 5 weeks after filing a complaint to get some parenting time. Do you have any recommendations for the viewer of steps they can take during that time period to maybe enhance their case, or to better yet, get any sort of quality time with their children?
Well, I recommend communicating electronically for sure. And what I mean by that is almost everyone has the ability to text message or email. So if your spouse has moved from the home or you're out of the home and they have control of the children, and I use the term control because that's really what we're talking about most of the time, I would text them civilly, not angry, because these texts and emails have a way of showing up later, asking that you be allowed to see the children, setting parameters up to see the child or children that you can hopefully follow. I oftentimes, when I have a client, I explain this unfortunate reality that the court's wheels spin slower than most people want, even though they're set up to be able to establish temporary orders regarding child visitation and parenting time. I will sometimes get on the phone and call the other attorney and say, look, can we set up some parenting time? It may not be precisely what the parent ultimately wants, but getting that contact, establishing that contact, easing the tensions is something that we can do. But it's not perfect. The one thing I definitely counsel away from is somebody going over, demanding that they see the children, causing some kind of a conflict that is traumatic to the children, getting the police involved, going to schools, getting the school officials involved. Those are things I absolutely do not recommend. If it takes 3 or 4 weeks to see your children, I think that's awful for a good parent. I think it's awful for the children, but it's better than seeing their father or mother arrested and thrown in jail.
Mark, I think you highlighted 2 very important things. One, create a paper trail. Don't necessarily have these communications through the phone. Do it through text message or email. And number 2, take whatever time you can get with your children in the interim before you get a custody order.
I think that's absolutely correct. I'm okay with people communicating with each other by either meeting or talking over the phone. I'm okay. But if you feel like the child is being withheld from you, or children being withheld from you wrongfully because one parent is just angry at you or what have you, the paper trail, as you put it, is important because he said, she saids are very oftentimes polar opposites of what actually happened. Somebody will say, well, that person was very aggressive. They demanded, they threatened, they did this, they did that. The other side said, no, I was very polite. I wanted to just see the children. I never raised my voice. I never used profanity. Well, how's the court going to figure that out? And so if you have a trail that says, look, I tried to see my child or children on these different occasions and you were denied that, that's not going to play very well. And in terms of going in front of the judge, when the judge or the friend of the court says, well, they tried on 10 different occasions and you wouldn't let them, why not? And this really goes on both sides of things. Parents, if you split up and you have the children and we have a parent that it's not a danger to the child in any way, allow access, even though there may not be a court order. Allow that access if you can, so that that parent can continue and maintain that relationship with the child. It's so important for the children to be able to have a relationship with both parents.
Mark, I think that's excellent insight. Viewers, don't forget to hit the like button and the subscribe button, and check in next week for our video about how child support ties into custody and parenting time.
Take care, all.